The last one I did was. So they started to win. Yeah, they just. Last week. Wow. Temporary. How are you? 2 months. So you cannot stand out. It's so on top of that.
She confirmed in person.
Okay.
Yeah, then into your son.
Good. Now we're just talking. It's been a while since you've been. We'll have to look into the screen. Sorry, I was coming down to you.
Very too. Oh, wait, Lisa's not here. I mean, she's here, but.
Yeah, I like it.
Good morning, everybody. Good morning. Hope everybody's doing well on this early unseasonable chilly morning today. And I hope everybody had a great weekend. We're going to go ahead and get started for this meeting today. And make sure everybody is in place. Okay. All right. March 29th, 2022. The Charlotte Board of Adjustment is now in session. I am Douglas Wilson, Chairman of the Zoning Board of Adjustment. Also sitting on today's board is Ms. Deborah Dryden, Mr. Tariq Hamid, Mr. Hamilton Court, and Ms. Krista. Also present Shad Spencer, our zoning administrator, Lisa McCarter, who just walked in, our planning project manager, Tim Gray, senior assistant city attorney. One more time saying your name. Jill Sanchez Myers, also our senior assistant city attorney. Terry Edwards, clerk to the board, and Candy Thomas, our. I would like to acknowledge, I'd like to start by announcing that we are conducting this meeting in person. This is actually the second in-person meeting of 2022, if I'm mistaken. There's a Board of Adjustment, and I'd like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance. We conduct eventually hearings on requests for the variances and appeals among other requests. Before we begin to hear the case of today's agenda, I'd like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this platform. First, today's meeting will be in accordance with the special legislation. Actually, I think I may be reading the wrong one. Let me make sure here. Okay, this is the right one. Just want to make sure. I apologize about that. Okay. Let's keep going on here. Also, each applicant would notify before being placed in today's agenda that this meeting will be conducted in person. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing their request using this platform. Notice of this meeting was provided to the applicants and the public in several ways. The notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified property owners of the in-person platform, and letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. The notice was also provided by placing signs on each property and by publishing notice on the city's website. The notice for today's meeting contain information about means by which you can access today's proceeding. Finally, any individual wishing to participate in today's evidentiary hearings are required to sign up prior to today's proceeding. This information was also included on the board's website. In regards to what type of hearing this will be and how it will, the application for a variance from the regulation in the zoning ordinance requires an application for that variance in the regulation in the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or zoning staff member will identify the case and recommend approval of the variance of any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions. The board has questions for staff, or if there is any reason the board wishes to move the case to the regular agenda. The chairperson then calls for a motion and a second to approve the variance. The chairperson will then hold a roll call vote. So again, what I just wrote was just how the agenda would flow today. The order of the agenda will be as follows. Parties who plan to give testimony who have a pro or con must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may also question the staff member. The applicant presents their testimony for this case, and then the board may question the applicant, and the staff member may also question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance, and then the chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each particular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call for the zoning staff for the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, March 28th, in order to be considered at this hearing. If your case is not appealed to the Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. The board will not specifically exclude hearsay evidence. It is given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for any individual who is not an active member of the bar to appear for another, otherwise assist or represent another at a quasi-judicial hearing on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use please contact the clerk and the documents will be provided to you. If as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider each request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with North Carolina General Statute 60A-388E. In order to receive a written copy of this decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will hear two cases today on the recommended agenda and one regular agenda item. Is that correct? Okay. Yeah. All right. And our first case number today be this is correct here, 2022-001. Okay. 3600 Sadler Road, presented by Lisa McCarter. And Lisa, of course, I will go ahead and swear you in. Do you, and Chad, I keep beginning to say this. Okay. Lisa and Chad, do you swear to affirm to tell the truth, the whole truth, and nothing but the truth at the matter at hand?
Do.
I do.
Okay. Proceed.
Okay. So I'm sharing it from my computer. Would I have to use my computer?
Yeah, just you.
All right. Our first case is on the recommendation agenda, and we haven't received any opposition for it. It's a rear yard encroachment variance, and the applicant is requesting a variance from the 25% encroachment allowance to allow two decks that encroach up to 92% into the required rear yard. And I'll give you a minute to look at your findings.
Okay, we'll see you may proceed.
Okay. Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R5 single family, and the property is located in the Lower Lake Wiley Critical Area Watershed Overlay. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. So you can see the existing home that's built very close to the shoreline. All right, so my computer just went black, so give me just 1 minute. Yeah, it's rebooting. Terry, do you want to see if it's quicker to pull it up on yours?
If you want to pull up to that desktop, can you
Okay.
just route the map? Outline.
All right, I believe we were on the exhibit number 3 aerial map. Exhibit number 4 is a close-up aerial map. Exhibit number 5 is background. The home on the property is non-conforming because it was built in 1960 prior to the current zoning ordinance regulations for the 35-foot rear yard and the 50-foot lake buffer. And you can see from the survey that the home encroaches both into that 35-foot rear yard and the 50-foot lake buffer. Exhibit number 6 is the variance request. The applicants wish to convert the existing rear stairs into a small deck that will serve as a landing and modify the existing deck. These changes will change the footprint of the nonconforming encroachments into the buffer and rear yard and increase the square footage of the decking by 125 square feet. In the lower Lake Wiley watershed overlay, encroachments into the 50-foot buffer are permitted with mitigation in lieu of a variance. The ordinance allows decks to encroach up to 25% into the required rear yard. Currently, the existing deck is encroaching about 92% into the rear yard. The applicants are requesting a variance for the decks to encroach up to 92% into the rear yard and modify the existing deck and build a landing for the rear stairs. And the site plan shows what's existing in red here and the newly proposed in blue. So up here is the little stairs that will become a landing. Exhibit number 7 is considerations. Staff recommends approval of the variance request with the following condition: that the applicant shall obtain an approved buffer revegetation mitigation plan in accordance with the Charlotte-Mecklenburg Water Quality Buffer Implementation Guidelines. The applicant has agreed to the proposed condition. The variance will not exceed the established rear yard encroachment, and the majority of the home is already located in the required rear yard area. Exhibit number 8 is further considerations. It'd be hard to locate the decks within a compliant building area because there's a well on the right side of the property. The applicant states that the septic and leach field are located to the front of the home, and the left side of the home is limited due to the location of mechanical, electrical, and utility locations. Granting the variance will not alter the essential character of the area and will not be easily detected due to vegetation screening the home from the street. Granting the variance will uphold public safety because the proposed wooden slatted decking is pervious and it won't increase the built-upon area on the lot. Mecklenburg County Stormwater Services is not opposed to the requested variance with the condition for mitigation, since wooded slatted decking is pervious and the project will not increase the built-upon area in the 50-foot buffer area. Exhibit number 9 is more considerations. The proposed decks encroach into the 30-foot state riparian buffer from the shoreline of Lake Wiley. So the project will also require state approval in addition to the local approval from Charlotte and Mecklenburg County. The North Carolina Department of Environmental and Natural Resources has indicated that the buffer will likely be granted pending mitigation, which will include the installation of native ground covers and low-maintenance native species, shrubs, and vegetation. And this was a markup that the state official used when he was responding to the email. Exhibit number 10 is photos of the property. So you can see to the left, kind of at an angle, the home, and then looking straight onto the home, you can see that there's vegetation screening the view of the home. And that's the end of my presentation, if you have any questions for me.
So I have a question. In the previous slide, you mentioned that one of the recommendations was to put some type of, I guess, barrier, whatever. The markup from the state, is that where it's supposed to go?
Well, that would be for state approval.
Okay.
So we actually do have Ron Eubanks with Charlotte Mecklenburg Water Quality here as well, who could speak to what local mitigation would be required if you'd like to hear from him.
Okay.
And you wouldn't have to make it a regular agenda item to hear from him since he's staff.
Okay. And before I ask the, if they have any questions for staff, I forgot to ask, do we have anybody in opposition? Okay, all right, great. Any questions for staff from the board?
I have a question. I don't understand. It says the proposed deck encroachment into the 30-foot state riparian buffer. I've never heard that before. What is that?
So it's a separate state requirement. So they have their own buffer regulations and 30 foot. So it's not as restrictive as our local 50-foot buffer, but they do have certain procedures and approvals that they also require if you get into that state buffer.
So it's not, I'm sorry, it's not in addition to the 50-foot. It's included in our 50-foot,
Yeah,
their 30-foot.
yeah.
Okay.
Yeah,
Okay.
it's within the same area, but it's a different approval process.
Okay.
Yeah.
So this is the homeowner's first step. If they get this approval, then they go to the next step to get the next steps of approval. Okay.
Yeah.
All right. Now, are these the existing decks right here?
Yes. So that red deck is the existing deck, and the angle of this, you can't really see the stairs on the back.
Right. But that's the one that they want to enlarge.
Mhm.
Okay. Thank you.
Just to clarify there, there's another set of steps on the other side.
Yeah, let me turn it back to that slide. So you can see up here, there's just a little set of steps coming down from a back door, and they want to make a landing. So this won't encroach, it'll actually encroach less because they're turning the stairs to the side.
You might identify where the beach field is, it doesn't show up on the survey.
Yeah, it's just what the applicant stated in their application, so I don't know the exact location. The applicant is here if you did want to open it up, put it on the recommendation so you can ask them, or put it on the regular so you can ask them questions.
Are there any other more questions for staff? And Jill and Turi, if we ask the applicant questions, they have to be sworn in, right? Okay, all right. Does the board have any questions for the applicant?
I don't.
All right, great. Okay. I said, is there a motion to approve or deny the variance?
Motion to approve the variance.
Okay, we have a motion to approve the variance by Mr. Tariq Hamid. Is there a second?
Second?
Okay, we have a second by Ms. Krista Long. Now move into a roll call vote. Ms. Long?
Yes.
Okay, Mr. Court?
Corey, yes.
Okay, Ms. Dryden?
Dryden, yes.
Mr. Hamid?
Me, yes.
Okay, Wilson, yes. Okay, the motion passes, the variance is approved. Now we will look at the finding facts and approval, conclusions, excuse me, of law. Any board members see anything need to be changed on here? I think everything looks in accordance to Lisa's presentation.
I make a motion to approve the finding of facts and conditions of law, Dryden.
Okay, there's been a motion to approve the finding facts and conclusions of law by Mrs. Dryden. Is there a second?
A long seconds.
There's been a second by Ms. Long. Now moving to a roll call vote. Ms. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Court,
Or yes.
Mr. Henry, Wilson, yes. Thank you very much. Our next case on today's agenda is, I'm trying to make sure I have it here. Case number 2020-130. Okay. Let's see, we have, oops.
Sure, there is opposition for this case.
Adoption for this case? Okay, all right, great. I guess, just for the sake of time, city attorneys, I can go ahead and swear in these folks now. Okay. Thank you. Okay, great. I know Mr. Murray, I know you're an attorney, so, I guess
Oh, swear.
swearing, yeah. Okay. All right, great. So, Mr. Murray, do you swear to tell the truth and whole truth in the matter of him? Okay, all right, great. And you, Mr. Wiley?
Mr. Andrew Rowe.
Andrew, and this is a person that's in opposition?
Yes, sir.
Okay, I got you.
Mr. Rowe is the
Yeah.
principal of.
Okay. He's a client. All right, so Mr. Rowland, I'll swear you in as well. Just for the record, can you state your name and your address again? Okay. And if to use the microphone, if you can just press the button.
2128 Lombardi Circle, Charlotte, North Carolina.
Okay, great. And do you swear to tell the truth, the whole truth, nothing but the truth in the matter of that hand? All right, thank you very much. Okay, Lisa, you may proceed.
Okay, this case is an accessory structure square footage variance request. The applicant's requesting a 767 square foot variance from the maximum square footage for accessory structures. And I'll give you a minute to look over your findings if you just let me know when you're ready.
Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R5, single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 1923 and has a duplex that was constructed in 1928. In the R5 zoning district, duplexes are permitted on corner lots with at least 10,000 square feet. And this duplex is an existing non-conforming structure because it's located on an interior lot that's 7,666 square feet. The duplex is the principal structure and has 1,020 heated square feet on the first floor, according to the Mecklenburg County real estate records. Exhibit number 6 is background. The code requires the total square footage for an accessory structure not to exceed the heated square foot of the first floor of the principal structure. In April of 2020, a permit was issued to construct a 1,787 square foot accessory structure on the property, which exceeded the maximum 1,020 square footage allowance by 767 square feet. Exhibit number 7 is background. On November 25th, 2020, a notice of violation was issued for the accessory structure because it exceeded the maximum square footage allowance. There was also a violation at that time because the second story of the structure was being used for an ADU, and that's not permitted as an accessory use to a duplex dwelling. So code enforcement worked with the applicant, and the second floor of the accessory structure is no longer being used as an ADU, but there's still the issue of the square footage exceeding the maximum allowance. Exhibit number 8 is the variance request. The applicant is requesting a 767 square foot variance from the 1,020 square foot maximum allowance for an accessory structure to allow the existing accessory structure to remain. And you can see in yellow there is the area of the accessory structure. Exhibit number 9 is considerations. Staff supports the requested variance. The hardship doesn't result from actions taken by the applicant because a building permit was issued that showed the total square footage. The applicant became aware of the violation when they received the notice of violation. Unnecessary hardships result from strict application of the ordinance because denial of the variance would result in removal or partial demolition of the structure. Unnecessary hardships result from conditions of the property because the rear of the property is within the community floodplain shown in blue on the aerial map. Significant alterations to the duplex structure would require the entire structure to come into compliance with the floodplain regulations. The applicant is not able to attach the structure to become an extension of the principal structure due to insufficient rear yard area. And the applicant pursued the purchase of the adjacent property to the rear, which is this little triangle right here, thinking that that would give them more rear yard area. They could attach it and it would become compliant. But that owner was unwilling to sell because they have a lot of easements running through the property. And the requested variance does not impact public safety. Exhibit number 10 is a photo of the front of the duplex. And that's the end of my presentation. If you have any questions for me, the applicant also has prepared a presentation and we have some folks signed up to speak in opposition.
Okay, so before we get to the applicant's presentation, do any of the members have any questions for Lisa? Okay.
So I just wanted to clarify. So it's referred to as an existing accessory unit or accessory building, but that's because it's been built. It was recently built, correct?
Correct.
Okay,
Yes.
all right.
So is the easement behind this? This is the front of the unit. They want the easement for the back of the unit, correct?
So are you talking about when they tried to purchase this property back?
No. I mean, where are they asking for, where does the existing structure end? There at where the red arrow is?
So right in here is where the garage is currently located in the yellow.
And that's the sign of the back of the property?
The back of the
Okay.
property, yeah.
Back garage, okay.
So what's the intended use of the second floor of the ADU?
I would let the applicant speak to that, but it's not used as a dwelling space.
Any other questions from the board? Okay. All right, Lisa, thank you. And now we will hear from Mr. Murray. And
Members of the board, my name is David Murray. I'm an attorney with the Murray Law Firm in Charlotte. When I filed this application, I was a member of my old law firm, but I've gone out on my own since that time. This is a variance request just about the size of the structure. We have worked with the city to resolve the other issues that were raised. Whether they were issues or not was up for debate, but we've resolved those. The duplex structure, actually, Mr. Rowe lives in one part of that duplex. And so I believe there was a question about the use of it. And did you want to answer the use of the garage space just before we get started?
Yes, the use and intended use is home office and bonus room space.
And Mr. Rowe, what kind of work do you do? And a couple of preliminary questions I always ask my clients. Mr. Rowe, have you reviewed the application and the PowerPoint presentation, and are they accurate to your knowledge?
Yes.
And you've hired me to testify on your behalf and prepare this presentation for you?
Yes.
Thank you. And so we have this duplex structure that's in the front where Mr. Rowe lives, and he built the accessory structure to the rear and went through the plan process. So went through the plan review process, as you'll see. There was an interpretation that was made during the plan review process regarding the way that they counted the square footage in the structure. And so when the permits were issued, there was no question about what was going on out there. The plans were submitted, the permits were issued, and then at the final inspection, once the structure was built, that's when the notice of violation was issued because the structure exceeded the heated square footage of the house. There is precedent. I could actually add another case. 3 out of the 5 board members, I believe, were on the Willow Oak variance that I had last year, where a permit was granted for a 15-foot side yard for a duplex. They started construction, they graded the site, they were putting the footings in. A notice of violation was issued, a variance was granted so that they can continue. So it's not unusual if during the process of construction, something comes up that the city issues a notice of violation, even when there was a valid building permit issued, as long as the parties are building in accordance with that valid building permit. The courts have said that that's good faith. And I always cite this North Carolina Supreme Court case because I think it has good language, and it's obviously it's not conclusive here on a hardship, but what it talks about is that when a building permit is issued, the city cannot be stopped from issuing a notice of violation to stop construction if a permit is erroneously issued. However, it's obvious that it presents a hardship situation because you're building in good faith, you get done, and then there's a problem. Your only resort is you either try to buy some land to fix the problem. If that's the problem, you can't do that. You try to possibly connect it to the house. That's not going to work, as you heard Lisa say earlier. So your court of last resort here is to ask for a variance. And so that's why we're here. Ms. McCarter already showed this, but this is the county record showing the existing square footage of the first floor of the duplex. This is the building plan that was submitted to the county as built 1787. I put this in here. I submitted with the application all the plans. But when we went to the city and said, look, we need this, we need to apply for a variance, we submitted all the plans showing that these were the plans that were submitted, that we were not hiding anything that was going on here. All these plans show exactly what was being built on this site, and it went through all the plan review process. There were, I believe, in the county records, 9 inspections done by the county of this site. And it was the last inspection when it was done, when the notice of violation was actually issued. So Obviously, we're here for a variance. I always like to review the variance standard. This is in the city's zoning ordinance, but this is also under 160D, which is in the general statutes, and it talks about this is the standard for when a variance is granted. And I italicize two sections of this part, and it's important here because the Board of Adjustment shall vary, any of the provisions of the zoning ordinance upon a showing of all of the following. So when we're looking here at what the petitioner actually has to do, the petitioner has a burden of production to show the 4 steps. And if those are shown, then the board shall grant a variance. Unnecessary hardship, conditions peculiar, not result in actions, public safety secured. So when we're looking at unnecessary hardship, the grant of the permit is the trigger here. And we've had these in the past where the permits come in, there's construction based upon the permit, and now we're here asking for a variance when the permit is issued. That's the trigger here that has led to the hardship. The hardship now is we have this structure that's on the property that is out of compliance. We don't dispute that it's out of compliance. And it was done in conformance with the plan review process. And as I said before, a variance is the applicant's last resort. The hardship runs with the land. This is not connected. If Andrew doesn't own this property, this is somebody else's problem. So it does not run, it does run with the land. It is not personal to this property owner. The hardship's directly related to the size of the legally permitted structure that exists on the land. The variance is directly related to the reliance upon that permit, the stamped and approved plans, and constructing the structure. No self-created hardship here. Again, there was an improper interpretation that was made during the plan review process. The plans were submitted. These plans were extremely detailed, as you can see. The plan reviewers knew exactly what was being built on here. This was not some vague, the hand-drawn plot map where you say my side yard is here. This was very specific. The city knew and the county knew exactly what was being built. Secures public safety, substantial justice. There is no public safety issue here. There's no issue. It's in the floodplain, but there's no issue with the floodplain permits. Those have all been obtained. The applicant lives at the property, so he's at the property. He uses it as his office and flex space. If the variance is denied, there's only the applicant is prejudiced. The structure that was legally permitted would obviously have to be demolished to such an extent to meet the ordinance. So when we're looking at substantial justice here and we're doing the balancing, there is no damage to the public. It's only for this property owner. Conformity with the neighborhood, there's detached garages with finished space all along Lombardi, and I have some aerials. In fact, I've done an administrative deviation for another detached garage that's on Lombardi, about 6 houses down. It's office zoning next to this property. It's actually got kind of a unique layout that there's almost kind of like a shared parking lot next door. There's a public park to the rear. So where the structure backs up is public. And one of the other kind of interesting things to note here, if the principal structure was a single family structure, not a duplex, then this structure could be an ADU and it could exist in the size and footprint that it is. So if the neighbor or anybody on the street wanted to build something similar, they could do this as long as it wasn't a duplex. So our trigger is a duplex. I'm not sure, and I'm not sure that Shad could answer this question, but the new UDO, can you have an ADU behind a duplex, or do we not know that yet? We don't know. Okay, can't. Okay. So the new UDO would not solve this problem. So we're still here for a variance. So this is an aerial picture from GIS showing, this is the parcel, this is my exhibit 4. This is the parcel, the 2124 and the 2128. The parcel that I did the administrative deviation on here, you can see this large accessory structure to the rear was 2020. That was solved with an administrative deviation. Full variance was not needed, but you can see it's not unusual to have detached garage structures on the street. This was an aerial just of the one that I did that was the administrative deviation parcel showing the size of the structure. There's other detached garages. This is on Lombardi Exhibit 5. This is showing the property next door. You can see this is actually all zoned office. So this is the last lot on Lombardi that's zoned residential. The use next door is, I believe, medical office space. And you can see it has a shared driveway and shared parking. And so it's a little bit unique here that you're not surrounded by residential uses. You have office adjacent and in fact sharing a parking lot with this. And you can see this is the structure that's at issue here. So you don't even have residential uses next door. You have office uses. This is the neighbors. Mr. Rowe, do you fully adopt my statements and my testimony and my presentation as if it was made by you in your own testimony? Members of the board, if you have any questions, I'll be happy to answer them. But we have presented all the evidence necessary here to be granted a variance, and I appreciate your approval. Thank you.
Okay, and Mr. Rowe, you're not gonna, are you gonna add anything else?
Yeah, you feel free to add anything that you'd like.
Yes, I wrote down some prepared things, but I kind of threw them out the window. You know, when I first wanted to take on this project, you know, we were trying to solve a parking problem, which is in the neighborhood, which there's a lot of parking on the street. I'm surrounded by multiple offices, 2 medical offices. And the intent was to build a garage. We asked our architect in good faith, who we hired, said to call the city and see what, you know, how the size and the interpretations would work out. We were given guidance by that architect that the square footage on the top floor was only what would be counted, as David's pointed out, toward the finished space rule. We proceeded with the design on that. That's why we spent the money to put this on paper, and we proceeded with building. You know, you as a professional that gets into this kind of situation, I honestly can't tell you that there would be anything else that I would do differently. I hire professionals to help guide us through these things, to know the things that I don't know. We did that as far as our architectural firm. We asked for guidance from the city on rules that we don't fully know the interpretations on. And every single time I was faced with, a new issue, a complaint or anything, I've only tried to work with the city and change my personal cost and my lifestyle to work with everybody and use things the way that people are asking me to do. So that's all we got to say.
Any other questions from the board?
Any questions from the board to either Mr. Murray or Mr. Rowe?
I have a question. When it was submitted to the city for a permit, was it submitted as an accessory structure, or was it submitted as an accessory dwelling unit?
Accessory structure. So on the permit, Ms. McCarter had an exhibit. It was a I can't remember how it was not an ADU. So it was never submitted as an ADU. It's behind a duplex, so it never would have gotten there. And so the permit, it was an exhibit to the city, but it was submitted as an accessory structure.
And so you were saying that it was a compliant ADU within the, if it were a single family unit.
That's the irony here is if it was a single family unit, we could go back and do it as an ADU and be in compliance.
So the square footage limitation maximum is below the ADU maximum and the height limitation is below the height maximum for an ADU?
Correct, because you can have up to 800 square feet that would be exempted from that maximum accessory structure. But that would bring the square footage.
800 is exempted from,
Yeah, because ADUs are allowed up to 800 square feet, so we could, 800 square feet of the ADU could be exempted if it was an ADU upstairs. And I think that would probably exempt the 767 in this case.
so it'd be a half accessory structure and half ADU, and the ADU portion would be 800 and the rest would be 1100? Not,
Okay, so let me show you.
I'm not getting the subtraction part.
Okay. So ADUs are exempted from that maximum square footage allowance for accessory structures. And you're allowed up to 800 heated square feet for an ADU. So how that would work in this case, let's see here. Okay, so if the garage, so it looks like we've got 297. This might be different from the actual plans that we had. So this, the base, garage.
It's a little bit.
Yeah, you said this is the
For our
upper story, right?
So here's what's different. So when we're just looking as an accessory structure, you have to stack all the square footages together. So the county's interpretation where this went haywire from our understanding was that the county was only counting the heated space, I think. I mean, this is why it's so confusing because the county was not including the garage space in the calculation. But that's under zoning, you're supposed to include the garage space in all levels for an accessory structure. But if it's an ADU, you get to back out any portion of it that would be an ADU. Now, we don't have that here because we can't have an ADU. So the 1767, if I was just using it, by the way, my example was more about the neighbor could build something equivalent in size, not that we can't do that. So I just want to be clear on that. But it's just interesting that if we had a situation where this was a single family residential structure and we had an ADU, we could actually pull out 800 of that as an ADU. I think that's essentially what I'm trying to say here. It doesn't apply in this situation because we're not single family. So we can't do an ADU. We can't do that. But when you're counting ADUs, you count them differently than here where you have to count all three levels to get your square footage. With an ADU, if that middle level, hypothetically, if that middle level was an ADU, you wouldn't have to include that middle level because it's less than 800 square feet. And then your square footage would be less than the first floor of the square footage of the structure. Also, an ADU gets to factor in the whole square footage. So it gets confusing when you're doing it. Hopefully the UDO fixes some of that. Well, the new UDO actually doesn't have an 800 square foot limit, right? It's just 50% of the total structure. So actually under the new UDO, you can have bigger ADUs. And I'm sure that's going to be coming down the pike as soon as it's adopted. So So I was just using that as an example, just to say, look, the size of this structure, if you had someone next door that has a 1,200 square foot first floor and they want to build a 1,200 square foot accessory, they could put an 800 square foot accessory dwelling unit on top of that and not be in violation of the zoning ordinance, and have a 2,000 square foot structure behind their 1,200 first floor heated space. So the ordinance does interesting things when you do these calculations. I think that's probably, our understanding was that the confusion came from stacking the levels of the structure as opposed to the footprint of the structure. And before this came to me, I'll be honest with you, I was thinking that it was the footprint of the structure, because I went to Shad and said, hey, isn't it the footprint? So regardless, we're here asking for a variance to hopefully solve this issue.
Mr. Murray, could you go back to your picture that shows the homeowner's property versus the medical center that's next door?
Yes.
Yeah, and so the homeowner built this accessory dwelling or this whatever in order to provide a garage, because I see there was no garage. I can see we're overflow parking from the medical center because there is no divider there that says don't, unless you had signs that said don't park here. Huh?
Right.
You know, they could always park in that homeowner's space by accident. So that was the original intent, was to provide, and then they embellished it with a bonus room. Is that correct?
Yes, that's correct. There's an existing old shared driveway easement between the two properties.
Okay.
Early 19.
Thank you.
Are there any other questions from the board, either for the applicant or for Mr. Murray?
So I don't think the accessory dwelling unit issue is part of the statement of fact anywhere. That's not even, no. Right, so it's not even referred to in any of the statement of fact whatsoever. Okay.
No, I was just using it as a hypothetical for the size, if the neighbor wanted to do it or something like that, because it happened further down Lombardi.
Any other questions before we move to Mr. Riley? Okay, hearing none, thank you very much, Mr. Murray and Mr. Rowe. Appreciate it. Okay. Next, we will hear from Mr. Kerry Riley, and I'll have to swear you in before you give your testimony. You can come up to the podium here. And Mr. Riley, just for the record, so our court reporter can record this, can you please state your first name, last name, and address?
Yes, my name is Kerry Riley. I live at 1826 Asheville Place in Charlotte, North Carolina.
Okay, thank you very much. And Mr. Riley, do you want to tell the truth, the whole truth, and nothing but the truth of the matter at hand?
Yes, I do.
Okay, thank you very much. And I'm assuming you have a presentation to show, or you just?
I do not, and I apologize for that. I'm just a resident of the neighborhood. I bought my house in the neighborhood Lombardi Circle. And I'm sorry I have to do this very verbally, but Lombardi Circle is a U that connects to East Boulevard. Asheville Place connects the bottom of the U back to East Boulevard. I live on Asheville Place. So if you're Freedom Park, Lombardi Circle, Asheville Place, Lombardi Circle. So I live on Asheville Place. I bought that house in 1993. So I'm very familiar with the neighborhood. I've been there 30 years. So Mr. Rose, a duplex, I have had dogs all my life, and I walk the neighborhood, and I walk to Freedom Park every day to at least twice a day to go around the neighborhood, if you will, and see the neighborhood. So that's my association with the neighborhood, if you will. I'm here to speak really on behalf of the neighborhood. There's a lot of people who have expressed concerns regarding Mr. Rowe's previous building, if you will, in our neighborhood. He has bought a house down the street a while back, and I wish I could read a letter, if I may, that was written by my neighbor, Miss Tracy Bonfield, who is unable to attend today. A lot of the people work. There's a doctor on call at the hospital. One works for underprivileged people. Bonfield works for Wells Fargo. Not that that's any particular interest, but I'm here to speak for the neighborhood, if I may. So this has been an ongoing issue, if you will, in the neighborhood. There was, of course, for COVID, there was code hearings, if you will, violation code hearings. One of them was to be on Zoom, and we were in attendance for that. At that time, there were 4 board members who had showed up and not the 5th one, and we waited patiently to go through the process. It was postponed then by Mr. Murray because there was not the 5th judge to hear the case, so he postponed the case until today. One of the things that I would like, and he did show that when, this is actually the my presentation, if you will, the only slide you'll see. You saw in Mr. Murray's a while back that he had the zoning posted in front of his duplex. That's where his zoning sign is now. This is the back of his house. This is the structure in question. These pictures were taken 2 days ago. He has no intention of ever being here. He did not notify the neighborhood. I'm sure that they were notified by letters, and you mentioned that it's on your website. But this is where Mr. Rowe currently has his sign, is in the back of the structure underneath, turned even against the neighbor's fence. So he didn't want anyone to come here today to speak on behalf of the neighborhood. So that's one of the reasons I thought I should probably stop by. So if I may, this letter was written by Ms. Bonfield to the board for the case, the zoning case that was canceled on Zoom, postponed. So if I may, this is addressed to Terry. Hello, Terry, my name is Tracy Bonfield. Email addresses, etc. My phone number is, I would like to speak at the zoning hearing case 2020-130 on Tuesday, January 25th, 9 a.m. against the developer CBD Lombardi Holdings. Tracy has lived at 1835 Asheville Place for 22 years, so she's right across the street from me. This particular developer has 2 prior violations on Lombardi Circle that were detrimental to our neighborhood. Related to this specific case, sharing because this demonstrates a pattern of violations and disregard for compliance with zoning regulations. First, he cut down 2.
This is a judicial hearing, so I have to object. This is a statement from someone that's not here.
Yes, that's correct.
I have to object on hearsay basis because they're not here to testify.
City attorneys.
Yeah, and I'll just remind the board that the rules of evidence don't strictly apply. So while hearsay is not specifically excluded, it is to be given only limited weight because as Mr. Murray indicated, the author of the letter and also as the witnesses explaining what other neighbors that their positions, they are not here to be heard, so they cannot be cross-examined by Mr. Murray. So that's the reason to give hearsay just limited weight, but it doesn't require to be specifically excluded. That's up to the chair, but the board can hear it, but please keep that in mind.
So Mr. Raleigh cannot read the letter, or
He can.
Okay, he can. All right.
If you allow that.
Let's make sure. Okay. Well, I'll let Mr. Raleigh read the letter.
Thank you. So back to the beginning of that paragraph, this particular developer has 2 prior violations on Lombardi Circle that were detrimental to our neighborhood. Unrelated to this specific case, sharing because this demonstrates a pattern of violations and disregard for compliance with zoning regulations. First, he cut down 2 historic ginkgo trees located on city property so as to create a parking pad for a residential house he was building. Not in her letter, but this particular house was built on 2011 Lombardi Circle. It was built in 2026. his house sold on 2027, is when the property closed. So we cut down 2 trees in front of this empty lot so he could increase the value of his structure. I think the city fined him $10,000, and then he built a parking pad, which probably significantly increased the value of the building, the house he was building. Second, he built a cinder block fence on the adjacent neighbor's driveway. Now, this is the 3rd example in this particular case the developer has. Number 1, exceeded the allowable buildable area of an accessory structure by 70%. 2, he has built a structure that, as I understand the zoning rule, does not meet the allowable use for structure. He has built a 2-story garage with an upper-level living unit behind the primary property, which is currently occupied by a 3rd resident. There are 2 residents in the primary duplex. The building is functioning as a rentable unit plus a 2-car garage. Again, living in the neighborhood, there were 2 people living on either sides of the duplex. Mr. Rowe did live above the duplex for a little while, or above his garage. I mean, further, because of the accessory dwelling as a residential unit, my understanding is that this violates the zoning setback rules in terms of the number of feet that the building must be from the property line. Our neighborhood is very dense and underparked as it stands even before adding this residential unit. If this developer is not stopped with meaningful consequences, his pattern behavior indicates that he will continue with such violations. Mr. Rowe is not an innocent builder, an innocent homeowner who mistakenly was tricked into building something by a builder who said, oh, this will meet city code. No problem, go ahead and build it. Initial permit that was issued for a 1-story garage. In terms of Mr. Rowe's question, or the question of parking with, again, the medical facility that's next to it, there's plenty of parking. For a duplex behind that, it could fit 10 cars. As a matter of fact, the 2 people that live there now normally park behind the house, not in the garage, and Mr. Rowe parks his truck in front of his duplex. So, I mean, I just feel that I have an innate interest in building. My grandfather was a home builder. Not that that's partial, but I just love building. I love seeing it. We'd walk down the driveway with my dog, the shared driveway between, and talk to the guys who were building the house. One of the people I talked to one day was the city official, Chip O'Keefe, regarding the city violations or why he was there and the code violations that were going on. He mentioned at that time that he asked me.
Mr. O'Keefe.
Fine. I asked Mr. O'Keefe how things were going. He said that he had asked the resident to remove. He asked Mr. Rowe to remove a 220-volt electrical system, obviously meant for a dryer to be in the upper unit. So he never had the intention, I don't believe, of using it as a home office. I don't see how having a dryer, a washer and dryer on the 2nd floor of a zoned 1-story garage would be anything but the intention of a living quarters. He also has a kitchen up there. It's a beautiful, beautiful spot. He's done a beautiful piece of work on it. But I believe that every time he sent a contractor down there or his builders down there, he felt and knew that he was probably in violation of the 1-story garage permitted for the property. That's really all I have to say. It appears to be something that he likes to do, is to, do something, if you will, not ask for permission, but beg for forgiveness from the city the zoning boards in order to continue what he likes to do in his properties. That's really all I have to say.
Thank you very much, Mr. Rowley. Before we have a rebuttal from Mr. Murray, are there any questions from the board for Mr. Rowley? Okay. All right, hearing none. Mr. Murray, do you have a rebuttal or Mr. Rowe?
Just
Question, do we have, did any of those aerials show your property, any of the aerials?
Yes, very close. Mhm.
Can you?
You'd have to go back to Asheville Place.
Lisa, can you, please?
You have to go back to, you're probably your furthest one out.
My question was, do any of the aerials show, Mr. Riley's property to show the distance from?
Place, if you go up to where the two L's are, 1826. There, that was my house.
Lisa, can you go to the drone photo? It was like the actual photo from, the aerial view.
The one thing also,
Next,
I mean, those same buildings have been there since I moved in and
I think it's this one right here. And Mr. Rowe can, not Mr. Ram, excuse me, Mr. Rowley, can you point your house is on here? Is it on here?
it is not on that area.
Okay, can't see it.
On the next street over, Asheville Place.
Okay. It was one that showed like the whole.
That, one did show both, if you're able
Oh,
to,
okay. I thought.
you did have it there for a moment, and thank you.
I thought it was one that showed.
Uh,
All right, yeah, this one I was talking about. Is this?
What's
Oh,
that?
it's,
See it,
it's
okay.
not,
Maybe one more. Yeah,
it
so
was just the one that had the plot.
it's probably not, I don't have an arrow that shows his property.
No, there was just on, this is the only place that shows it, there it is. And Mr. Rose, what we hear the patients
It is right over here?
Yeah.
Okay, I got it.
So I have a question for maybe it's Terry or Shad. The notices that are mailed are for people within 300 square feet. So if this property is, again, this is a Polaris measure, right? If this property is about 500 square, I mean, sorry, not 500 square feet, 300 feet away. If this property was about 500 feet away, then this owner would not have been entitled to a mailing of notice.
That is correct.
But I would have been entitled to see a zoning ordinance outside of his house, which he hid in the garage behind his house. There would have been a posting of the sign in front, which he has not done. Second hearing.
The city posts the signs out front, correct? Okay.
So the sign then that is turned toward the fence behind his house should have been pulled out by a city official and posted in front of the property.
No, sir. State statutes require us to go and post the sign on the property between 10 and 25 days.
Okay, there was no sign.
I took a picture of it.
That was before, that was the January 20th. That was the last one. That wasn't this one.
Okay, so
He did, okay. Well, then he took it down and moved it to the back of his house.
So Lisa, if you can go back to, I think it was in your presentation where you had the sign in front of the house.
That's the original one.
There is a sign there. Certainly, I thought that that was before. The current location of the sign is in the back structure turned toward the fence.
Okay. And so, Mr. Rowley, you're saying that this sign in the front was then taken to the back?
It's not there. If she said she posted it, I'm totally fine with that. The last 3 weeks, it's been in the back of the house. Again, I walk by the property twice a day, walking my dog. It's,
And so you're saying that, you're saying that,
I'm not sure who did it. That's the location of it right now. Behind his structure, painted, pointed toward the fence. And that was on his one slide that he had of my evidence. You can see where that sign is currently.
and so you are suggesting that Mr. Rowe could have
Someone-
taken that sign and moved it to the.
And certainly if Mr. Rowe was aware that he should have had that sign posted out front, he might have called the city and asked, where's my sign?
And Lisa, is that a violation of a property owner removing a zoning board of adjustment sign from where the city places it?
It's helpful. I wanted to ask you, so in government exhibit number 10 in your photograph,
where there is a yellow sign indicating case number 2021-30 in front of the dwelling. Did you place that sign in front of the dwelling?
Correct, I believe on March 11th.
March 11th, okay. And that was, and by state statute, it has to be placed on the property 10 to 25 days before our hearing today, right? Do you check the sign anytime after you place it?
No, I just go up to pick them up the day after the public hearing.
Okay, so all we can say is what we're required to do by state statute, which was done. And I don't believe that the zoning staff can comment to what happened after they placed the sign.
But there's no violation for a homeowner if they move the original sign over.
The intent of the sign being placed there is to notify the community about this hearing. I don't know that the statutes speak directly to a violation.
Okay, all right. My apologies, Mr. Raleigh, I just wanted to clear that up. I just wanted to clear that up. I didn't mean to
No, that's fine.
interrupt your
Appreciate it.
presentation.
I have to ask a question.
Yes, sure, go ahead.
So the structure was permitted by the city through zoning, not the county, the city, through the zoning department as an accessory structure that totaled 1,797 square feet at the time it was permitted and approved. Okay.
As a one-story garage.
So that's what I want clarification on. So
Clarification of the permit was a one-story garage.
So the permit was amended to include a second story?
So all the stories were permitted.
At the,
Plans clearly show this river.
so it was not permitted as a one-story structure?
There's an exhibit that Mr. Carter submitted that showed
The box that was on the property that states construction of 2128, when you opened it up,
two-story.
I think that's the amended.
I'm not sure if sometimes.
So that's the Mecklenburg County approval that so you've got, I mean, the city approval is a portion of that county approval. So the county said, okay.
Mr. Rowe.
Yeah, sure, go ahead. Yeah.
Mr. Rowe, was the original permit submitted as a one-story or as a two-story?
No, not to my knowledge. The plans have never changed. And we,
For that building permit and stamped plans.
I would have to go through pictures on my phone to find that, but the lockbox, when you open it up, said permitted for a one-story garage. I would have that picture on my phone, but it would take me a while to find it.
Precludes you from being able to occupy the garage or to lease it out to someone else. I think because of the duplex that requires only two parties to occupy structure, and this is accessory, not dwelling. I guess what prevents that from happening in the interest and concern?
So the city, well, you can talk as you know, sure.
what I can speak to is what I did, and I've never tried to lease this as a third unit. With that, I have had every intention. I've lived in 2128 for the past year and used that as with it. Now, I can't say that what's been in all the conversations with Shad, Lisa, people, I've gotten different interpretations of ADU, an accessory structure with it. They're all over the place. But that's one of the reasons why I hired David, is just say, listen, how can we use this space? What's the definition between a bonus room and that? With it, and to speak to something that that Carrie said with it, nobody's told me that a washer and dryer can't be in a bonus room on it. With it, the target, every time I've been given some kind of guidance and gotten on a call, and there has been a lot of time that's passed that I've lived in there, I've tried to comply with that. So I don't have any intention to lease it as a third unit. Every time, most recently, the city said it's part of that conversation. They asked for the shower to be removed. We did that. So any kind of interior components, there's not a kitchen in there. With it, and Chip and the zoning administrators have been inside the unit. I've said, take it out. That's fine. Just tell me what the target is so I can understand how to use my property. So
I guess this is more of a question for staff, but can you clarify that an accessory structure cannot be habited? It can't be a habitable space, so it can't have a shower, it can't be lived in permanently. Is that the definition of, or is that excluded from the definition of an accessory structure, that it's not a habitable space?
What we had to do was work with them on modifying what was out there at the time that Chip O'Keefe, the building inspector, went out there and noticed that it had the appearance of an accessory dwelling, which Chip's boss, kitchen facilities, and back facilities, where there was enough in there where someone could reside. So you have to make it that structure such that it is no longer where someone could reside. So like a full bathroom, there's a clue. So they removed the I think it was just a shower, shower, but they removed that. So now there's no areas where you can bathe. So now it doesn't qualify as being an accessory.
And also the definition, I mean, board members that have been on this board understand the definition of ADU is rather in flux. I know we're talking about ADU and it doesn't even apply here, but the definition of ADU also changed recently too. But the county building code has more of a say in what an ADU is than the zoning does. So if it gets through the building permit, the city is deferring to the building permit department to decide what the difference between an ADU is and what an accessory structure is. And if you have a bedroom with a bathroom and a kitchen, if you drive down certain streets in Eastover, every detached garage has a bedroom with a full bathroom. It might not have a kitchen, but is that an ADU? I don't know, but that's probably a topic for a bigger discussion. But Mark Fowler and Chip O'Keefe, who, if there was an issue, I'm sure Mark would be here. They went in with Andrew and went through and said, look, the shower just cannot be. And so the shower.
I just want to point out to a statement of intentions and in what's actually happened in the past year with it. That I invited that meeting. I said, guys, I need to understand how I can use this space. Tell me. It was not there with it. It was not clear. We can build a shower, and then they said, no, this is a violation. Take the shower out. They were making additional calls, and Mark Fowler and Chip, I'm sure that's in their records, they made that determination. That was not clear at that time. I said, fine, tell me what in here we need to take out of here so that I can be in compliance with accessory structure. And that's still my stance here today with it. I moved into 2128. I have no intention of using that space as a leasable unit, an Airbnb, anything that reasonably could be determined as an ADU dwelling unit. And I would honestly say that it's really not clear. The building inspectors, even having that on-site meeting with them and saying, okay, well, here's if you go to the whole arguments about ADUs and hot plates and other cases and things like that, it's not clear, but I don't want to use it as an ADU. I don't want to use it as a rental unit. That's not my intention, and that's not part of this case.
So the original plans that were submitted included the bath, the shower, and they were approved that way. You know, just trying to understand the timeline. And then you started building it, the building inspector had you modify it before the notice of violation occurred. Is that right?
The notice of violation occurred at the final inspection. So there were, I think, on the county records that shows in the non-inspection, I submitted, one of the plans that I submitted in the application actually shows on the second floor, washer and dryer, shower, toilet, sink. I mean, it shows everything. I mean, it's
Ma'am,
all
to
there.
your point, as far as the shower, the rule or I guess the guidance from Mark and Chip about blocking off the shower didn't come until way after this process. This was in January of 2021. I did that at my own election to say, listen, I don't want my neighbors or anybody thinking that I have the intention to use this as an uncompliant third unit, because that's not the case.
As the board,
With it for over a year, that's what's consistently happened in the space. It's used as my own office.
and as the board can see, you know, we originally filed an appeal just to preserve that right. So we obviously withdrew our appeal because the whole issue after with ship was on square footage. So it's not.
And before I go to Mr. Raleigh for a response, Mr. Miller, you mentioned in your presentation that there were 9 inspections done until there was a violation found.
I believe so. It's on
Yeah.
it would be on the county's website, so I didn't have that document, but keep in mind, when you go through the inspection process, you have mechanical, building, plumbing. I think those are the 3 inspection processes. And then you have your building final inspection. There's levels of inspections that take place here. And when you look on the county records, there's multiple levels of inspection that take place, and then it triggers the violation. And that was triggered at building final inspection.
Okay, so it wasn't the fact of 9 different inspectors coming in, it was just a process.
Not the same inspector.
Okay.
I just don't know the ins and outs enough of the inspection process. I don't even know if it's city people or county people, but it went through the inspection process. Because if you take the Willow Oak, and I know 3 out of the 5 members are on Willow Oak, if you take the Willow Oak variance that we had in September of last year, that was the initial inspection that triggered the notice of violation for that setback encroachment. They only had footings in the ground. So that was the initial inspection. They found a violation and they went ahead and issued the NOV. The city issues NOVs when they find the inspection. And that's to stop construction from proceeding. Well, here, when the NOV was issued, construction was done. So the Willow, as soon as we got the notice of violation, we stopped construction. So those footings sat on the Willow for months until we were heard.
Yeah, I guess I was just confused. I don't know. I know this is, and I'd be right to say, but I don't understand why it would take 9 times to do an inspection to find this.
Yeah, and I'm not staff, but from my experience with the permitting system, the county has building inspectors and the city has zoning inspectors. And so the county will come out and do a building inspection, and then the city will do a zoning inspection, and the city might do it at the beginning and the end, or they might do it just at the end. It appears they did it just at the end on this one.
Mr. Raleigh, do you have anything to add?
I did find, and again, I apologize for my professional and not having documents and so on and so forth regarding this. I did find the picture that was inside the box, if you will, for the original building. It is permit number, let's see, B3583793. The issue date is September 16th of 2019 to DCG Construction. The parcel number, it says the description of the work is to be Lombardi duplex garage structure, detached garage, 1-story.
The issue date on the plans that were submitted is March 4th of 2019.
and this might, so, and one other small thing regarding, Mr. Rose in the neighborhood, when the duplex was first finished, it was not a particularly wonderful looking building. Again, I think that, Lisa had mentioned that the duplex was built in the 20s. It was beginning to fall down. And he did a wonderful job of repairing the duplex. And then he rented out both sides and went to the back where his structure was. When one of those tenants moved out, that's when he occupied the front of the duplex.
Mr. Riley, you had mentioned earlier in a presentation that you said that Mr. Rowe has other properties or he's done this before.
There was a house, again, the house that he built is at 2011 Lombardi Circle. There was a house there that he bought, which had a vacant lot next to it. He then just decided to build on the lot. There were two of the trees that were rather historic trees in the neighborhood, and he took those down to create a building pad. And then when the city came along and said, you're in violation, he was fined. But he took the trees out prior to having permission on the planning strip to do that.
I have to utterly object. 2111 Lombardi Circle. I'm not a residential builder. I did build the house at 2011 Lombardi Circle. I have never developed that property. I never had an ownership stake on it. I never directed the taking down of those trees. As a matter of fact, you can actually call Laura Reed, who's the assistant arborist for the city of Charlotte, and you can back that fact up. I never directed the cutting of those trees down. I've never had any ownership stake in that whole project. You can ask the two homeowners, Carrie, Alex, and Lauren Harkey, and they will tell you that. That is such a blatant false statement to say that I own those, I directed the development, or had any kind of ownership stake on it. It's a matter of public record. Look at the tax records, and you can see who owned those. They're with it. I will swear on the Bible for the rest of my life that is such a false statement. And
speak to the matter out there.
Excuse me, sorry, if I may interject. One of the commissioners has briefly left the room, so I would ask everyone to stop presenting testimony. And I'd recommend if we just take a short break and Mr.
And let me explain why we're doing that, just to make sure that we have fair representation.
When we reconvene, if you could just restate the last few statements that you presented, that would be great.
So it's 10:33 now. Let's come back at 10:40 then. Is that good? All right. So about 6-minute break.
I have a realtor that's supposedly doing some of that stuff. So it's interesting because she struggles to find new structure. So other things, what is it? That's I often.
My fear is that, the tree deciding what was out in the kitchen, and someone's come along. And everybody was like, guess we have to take a look at this. The idea is, maybe someone's want to, that's why I live never knows. Never. Expires. Everybody in the house. Just to get to the fence. Last time. Wow, sweet. It's not really, like even we all, like, they would say, we're the agreement. I don't know. They were going to be able to get rid of but anyway, the remodel on the house is kind of a lot more than I expected. Just to put a closet. The next time I'm going to wow. I'm taking that. Get it down. The dust or everything. But now that that figured out. Yesterday I was supposed to have so I got
We're just working.
It is space.
As well, thanks.
To see the person bring out some access to them.
Yeah. Oh, Miss Lisa. Okay.
Up here for one more.
So we will begin shortly, just waiting on Lisa McCarter to enter back in the room, just in case we have questions for her. Okay, now we are back in session. And Mr. Rowley, I'm going to give you another quick moment before we wrap up testimony, if you have anything else to add. Let me backtrack. Sorry about that. Mr. Rowe, you were speaking at the time of our recess. My apologies. So if you just want to restate what you were saying.
I was asked to repeat my last comments, in regard. I started to make a comment to, Carrie's, testimony about, Clearwater Development Partners, myself being the developer and owner at 2011 Lombardi Circle. I was not the developer of that project. I was never an owner of that property. I was the builder of the property. None of the direction of anything that Gary references was my decision or my company's decision with that. I'm not an active residential builder, and I do not have a pattern of violations. I've done plenty of commercial projects in Dilworth, and I've never had a zoning violation before this project.
Thank you. And Mr. Riley, you have anything to add there?
I do not, no.
Okay. Does this conclude your presentation?
Yes, one other question I would have regarding, if it was, understanding of the initial permit was for a one-story garage, and obviously we have a structure that's a little bit different than that. I believe that the closeness of the footprint of the property might violate setback restrictions regarding the fence, the border to the property that, it's behind his house also. I don't know what the zoning ordinances are, but if it is in fact a two-story structure versus a one-story structure, wouldn't that be a different permit for the footprint of the house in regards to setbacks of neighboring properties? I don't know the answer. I'm just asking the board. So that's all I have. If anybody else has any other questions, I'm very willing.
Lisa, is that a question you can answer by Mr. Riley? He was asking that for the board, but that's more for staff.
I'm not sure what it's, we don't require permits for things.
No, not the fence, but there's certain setbacks from the fence, which would be the property line for the adjacent property. If it's a one-story structure, it has to be a certain distance from the property line. If it's a two-story structure, is that the same distance, or would it be a larger distance or a less distance for that was my question. Yes.
An accessory structure up to 24 feet height would just have to maintain the required side yard setback for that zoning district, which is zoning district, which is R5, so that'd be a 5-foot side yard. The other structure.
Okay. I just didn't know. Thank you very much for allowing me to.
Thank you very much. Okay.
Members of the board, I have to just reassert my objections for the record, since this is quasi judicial, to Mr. Riley's testimony. It contained hearsay and speculation. And also I object on the ground of materiality, given that this is not an adjacent property owner. So just stating those for the record. Thank you.
Okay, so noted. Okay, this concludes the presentation of evidence. The board will now begin its deliberations. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. So, board members, I just had a quick discussion with Ms. Sanchez Myers, and I'd asked if she could just inform us or remind us what the board's responsibility is. I know she's trying to pull it up, yeah.
Thank you. I was trying to find some of the language from the ordinance. But the one thing that I did want to caution the board, and I've already kind of given you some guidance regarding the hearsay and the testimony before you, but I also wanted to sort of remind you that the evidence that you base your decision on should be relevant to the 4 factors, and the decision should be made not based on personal circumstances of the applicant, or whether you like the applicant, whether you think the applicant is a good person, whether you think the applicant is not a good person, or, those kinds of anything personal circumstances related to the applicant. The relevance of if this applicant has violation on other properties. I would caution you on the relevance to this particular application and the hardship to this particular property. And that's all I kind of wanted to just give you a little guidance there.
Thank you, Ms. Sanchez Myers. Okay, board members who would like to go first on his or hers thoughts about this variance?
Okay, I'll start. I'm looking at our 4 requirements. To start, I do have some concerns about the ambiguity that transpired in this permitting process. It's very difficult when, as I believe it was Mr. Court mentioned, that sometimes the county expects at the beginning and at the end. Well, if you do it at the beginning and you miss it, and then the end and it's already built, that behooves the county to make some kind of adjustment so that the homeowner or the builder is not held holding the bag at the end. That said, as we listened and as the homeowner readily agreed that he did put in a full shower and a full bath and a washer and dryer and a kitchen, which would lead me to believe that he expected somebody to live there. You don't usually put those amenities into a building project just for your own edification. Now, I can see a washer and dryer if you have maybe linens up there that you needed, but if it's an office, I don't see the need for that. But evidently, he's amended that, and the city and the county are satisfied with his changes. With those concerns in mind, however, I can see that it would be an unnecessary hardship if we did not approve this ordinance because he's going to have to tear down the structure. And the hardship did result kind of from the peculiar property because it's a duplex. I do feel their pain because if it was a single family house, we wouldn't even be sitting here today. But it's a duplex. And they have different code enforcement and zoning rules. The hardship doesn't result specifically to actions taken by the applicant because of the ambiguity in the permitting process. And to request this variance, it is consistent with the spirit of an intent of zoning that, and it doesn't affect public safety. So those are my thoughts. So right now, I would tentatively, upon other comments from the board, vote to approve this variance.
Thank you, Ms. Dryden. Mr. Yeah, I'm sorry about that.
I appreciate the time coming here today to review this, and I guess to play off of what Mr. Ryden just said. This was never submitted with a kitchen, so I could see this. The intent was really to submit this as an office, maybe a glorified office, and people come to your office. You may need some clothing there, and you may need to be able to wash that clothing, and people work long hours, and even looking at the shower to me could indicate that this wasn't the intent, was not to design this as something other than at home office space. I do think the applicant did hire an architect that does a lot of residential construction in Charlotte. As an architect, I can't fault another architect, but it does kind of come into question to me, should not that have a design professional understood what some of the limitations of an accessory structure are? That being said, it did go through permitting, it was approved, the structure was built, and until the final inspection, this is when notice of violation was brought up, which does create an undue hardship for the applicant. I do think the request for variance is consistent with the spirit and purpose of the intent of the zoning ordinance. And also to play up from Ms. Dryden, I don't see that there's a public safety
issue in justifying this variance. So for that matter, I'm in favor of approving this variance.
So,
It's hard not to be emotional. Emotions always tend to run high with these things. However, it really comes down to the fact that building permit was issued in error and the applicant didn't find out until the very end, when the notice of violation. I think that good intentions, working with when, it was brought up about the shower, et cetera, et cetera. So I'm inclined to approve the variance request.
Mr. Court?
I think I similarly feel like the application of this as a accessory unit and taking out of consideration the accessory dwelling unit portion of it. I think that it was issued in error, and I don't fault the property owner for that. I think that the plans are clear that it was intended to be a accessory unit and not an accessory dwelling unit. And when I look at the intent and purpose of the zoning ordinance, and I look at the square footage limitations, and I look at the overall result of the property, you look at the footprint of the accessory building, the footprint of the main building, the area coverage is in general consistent with maximum area limitations, and the structure as permitted would qualify height-wise, certainly, as an accessory dwelling unit because it's only 24 feet tall, and a lot of concessions were made in order to do that. So I would be inclined to support the variance as well.
Okay, and as my thoughts on this case, I think that there has to be some type of, and I'm not sure if I'm allowed to say this, but I'll say it anyway, some type of a reform when it comes to these inspections. I've been on the board now for a number of years, and I've seen cases come before us where you have an architect comes in, says, I've done this, and I got violated at the end of the building process. And I think that's not fair for architects and neighbors as well. And then you have neighbors coming and saying, well, I saw this ordinance and it said this. So I think there has to be some type of change there because it makes the board's job, in my opinion, harder. And it makes the job of builders and developers in the city and our neighbors in the city, makes their job and living environment a little bit harder. But as my fellow board members said, and as the city attorney said, we have to make decisions as a board based upon what the North Carolina General Statute requires us to do. And although I consider the members of this board, as well as myself, everybody in this room, neighbors, because we all live in this city and we love the city and we want to see the city grow fairly for everybody. We have to take emotions out of it and we have to look at what's at hand. So with that, I would be inclined to approve the variance. Before we end deliberations, are there any other comments from the board regarding this case before we end deliberations and move into period of voting? Before anybody else says anything, I did forget to mention that any aggrieved party, once a decision is made on this variance, if you would like to receive a written copy of the decision, you must file a written request for a copy with the board clerk, who is Terry Edwards, or myself at the hearing at the end of today's hearing. And I think that they have how long, Terry? Do that about 30 days, I believe it is. Okay, just wanted to put that in the record. I failed to mention that. Any other comments? Okay, So deliberations are now closed. Now we will move into voting. Is there a motion on the floor to approve or deny the variance?
I'll make a motion to approve the variance.
Okay, there's a motion to approve the variance by Ms. Long. Is there a second?
Hamid, second.
Okay, there's been a second by Mr. Hamid. And now I'll do a roll call vote. Mr. Hamid,
I mean,
Ms. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Court,
Court, yes.
okay, Wilson, yes. The variance has been approved, and this concludes this case. Thank you.
Mr. Chair, the
There's- And my apologies about that. Now we're going to facts, finding facts, conclusive law. And
I make a motion to approve the finding of facts and conclusions of law as written.
okay, motion to approve the finding facts and conclusions of law as written was made by Mrs. Dryden. Is there a second?
Long seconds.
Okay, there's been a second by Ms. Long. Now moving to a roll call vote. Ms. Long,
Yes.
Ms. Dryden,
Dryden, yes.
Mr. Hamid,
Me, yes.
Mr. Court.
Court, yes.
Okay, now this concludes, and Wilson, yes. Now this concludes this case. Thank you very much. Next on the agenda is the approval of the February minutes, which every board member has. Don't know if folks had a chance to review it. Is there a motion to approve the February minutes?
The court moves to approve.
Okay. Motion to approve the February minutes by Mr. Court. Is there a second?
Me, second.
It's been seconded by Mr. Hamid. Now moving to a roll call vote. Mr. Court,
Court, yes.
Ms. Long,
Long, yes.
Ms. Dryden,
Dryden, yes.
Ms. Hamid.
Me.
Mr. Hamid. Okay. Wilson, yes. All right, the minutes have been approved. I believe that's everything on the agenda this month. Okay. All right, if there are any more further business, all right, hearing none, this meeting is adjourned. Thank you very much.